So, Mr. McNeil, how much longer have you got, do you think?
I would hope to be no more than 10 minutes.
Right,
maximum.
okay.
And just I'm conscious that Mr. Hart needs his say. Just to close off a couple of points then.
Yes.
With regard to the first ground and Section 27 and Adams and options.
I see you were in it, Mr. Whitty. I've had a go at trying to digest it, but I didn't find it at all easy. So
No.
if you have got something to help us with, that would be...
The main point is, I mean, it's almost a point that, first of all, it's a useful illustration of the same type of claim, which is a Section 27 claim, albeit with a cross-border element in our case. So it illustrates how it works. But the principal point is the one that Sir Arthur Conan Doyle made famous in Silver Blaze, the curious incident of the dog in the night time. It's that nobody, two leading counsel for the pension provider there, nobody thought that Section 27 wouldn't bite on the relationship between that investor and his pension provider because there was no agreement. And it's
the paragraph you took us to, Lord Justice New said, but the rights under the SIP scheme are fundamentally not contractual.
Yes.
Would you say your rights under the trustee are not fundamentally contractual? That doesn't address the question of whether or not it's a separate contract under which you can sue.
Well, we've always understood it, that there are two separate roles for Castle, which is as administrator and trustee.
Yes,
and that the administrator role is the contractual role, and the trustee role is a classic property holding role with fiduciary obligations and powers.
So ground one.
So ground one is that. So we say we have the better of the argument that, unsurprisingly, no respectable professional financial firm operates without terms and conditions which is drafted itself. And in this case, we say the terms and conditions, whilst unsatisfactory, clearly relate to the provision of services by Castle as a scheme administrator. The initial effecting of a successful and compliant pension transfer being the first service, and then a continuing service of ensuring it remained a fiscally approved scheme by the revenue.
It's not how you put it this morning. This morning you simply talked about the initial effecting.
Yeah, the initial
effecting. And now you're saying, and continuing under the agreement.
Well, that's the second bit, which we that's where the ongoing fees go to, for example. So I'm just thinking about the initial fee and ongoing fee. The initial fee is paying for setting up and effecting a pension transfer. But we say qua administrator, it's a contractual relationship. Qua trustee, it's a fiduciary relationship. But the attack of the claim form is on the initial arrangements to transfer. We say that's the vice in this case.
Okay.
On specific invitation, I mean, we do just rest it largely on Gabriel, but also on Reliant Co, the most recent of the 6 CJ EU cases. But Milady did want me to look at the emails, and just so you're clear about my submission on this, we say that there's enough evidence, and there was enough evidence before the judge, that the relationship was one of, in old-fashioned language, middleman, or in Castle's own language, that Montague Smythe was an introducer of business. And it's just interesting to contrast as two parts of the judgment here. So in the core bundle, at page 47, paragraph 4, in the recitation of the facts, paragraph 4, He says the QROPS were promoted principally by Montague Smythe, a Cypriot firm, who operated from an English address in Waterlooville, but was not authorised by the FCA under FSMA to conduct investment business in the UK. So the judge has rehearsed that as uncontroversial in his summary of the facts. And that is borne out by all of all the documents in which, but principally, let's take the application and the letter, welcome letter to Mrs. Dooley, which Castle itself describes the role of Montague Smythe as introducer, and it pays it as an introducer. And
we see that. Sorry, we see that from the fee schedule, do we?
From I think it's page 10 in supplemental, and for the page 8 for the page.
Is that the £2,000 payment?
That's right.
It just says fees,
page 11.
Right?
Fees, yes. Okay. But on the welcome letter on page 10 describes him as introducer, and says, in the first instance, contact your introducer. So envisaging a continuing commercial relationship with the UK-based introducer. And so our evidence before the judge below was that in the evidence, in the witness statement of Mr. Wilson, it's at page 70. The paragraphs I was looking at before the break about Montague Smythe and the other introducers. And it's the absence of any evidence which contradicts this relationship of introducing, promoting, arranging, which appear to be common ground. So in many ways it's surprising that the judge starts where he starts at paragraph 4 in the judgment. And then his reasoning on this, just so we're clear, as far as I can see, is at paragraph 72 on page 65.
Well, that's why I thought the emails are important, because you go to the judge for simply referring to the letter of the 2nd of June.
Yes. So that's his reasoning, really, on ground 2.
But in relation to that letter, you've obviously pointed to something in it, and it was what, just the evidence of the relationship between Castle and Montague Smith?
Yes, and the admission that there were terms agreed between them. So I'm taking your ladyships through it, but it is an important letter. It is Castle setting out its stall on what it says about its relationship to Montague Smythe. It concedes a commercial relationship. It concedes payment of fees. It concedes that tasks like money laundering compliance were delegated to it. The evidence in my submission was not merely sufficient for the test, it's way over the test that is required for establishing jurisdiction on the specific invitation point. But at the very last point, though, is that if I'm asked to sort of nail down a specific invitation, I'm happy to say that the provision of application documents and associated documents to each of the investors by Montague Smythe would encapsulate the specific invitation for the purposes of jurisdiction. And we do see that in the emails, in particular the email which the lady referred to, which is the rock god one. Page 61, sorry. So this is the case of Mr. Ball, another claimant. It says see below Mr. Martin Ball. And you see that he's provided with, by Claire, with a montaguesmythe.com email, the personal details form. And if you look at that, you'll see it corresponds to the one from Mrs. Dooley.
I mean, this does look like, obviously there must have been an exchange of details, but this, on one reading, is a pretty early communication. It looks like it's the first time application forms are being provided and what the whole thing involves,
Yes.
and how the process ahead works. It doesn't look...
Yes. But indeed, if we were exploring this at trial, it would be something that we'd want to get into more, and obviously there'd be witness statements from either 60-odd claimants or a lead group of 6 or 12 claimants or something along those lines about how it was promoted and arranged. And if it's said that that was necessary for the jurisdiction hearing, we have Mr. Wilson saying they were all basically approached in the same way. Those are our instructions. They've all signed the same paperwork. It was all involving Montague Smythe. If it was being contradicted on the other side of the court, we might have condescended to greater specificity, or the judge has said, go away, I want witness statements from each of the 62 saying how they were approached, but it would be more detail. But it's not really an issue that they were introduced. The question is whether that introduction is sufficient for the statutory language of Article 13. And in my submission, introduction and invitation are, if not synonyms, are pretty close together. So on ground 2, we say it's clearly within the type of mischief envisaged by the report that Malone Friend relies upon as well on the European documents, Juliana and Lagarde, and it's also clearly within the scope of the obvious purpose and policy of the instrument. It would be a much longer bundle if we had those witness statements from 60-odd investors to wade through. But there's nothing an issue between the parties about this. This is what happened. The question is, what is a proper legal characterisation of what has happened? And we say it falls squarely within the Article 13. And this is really a matter where we said the judge didn't really exercise a kind of judicial common sense and pragmatism advocated by Mrs. Justice Cockrell in her helpful guidance on this point. And this court is, we say, entitled to say the judge was wrong, clearly erred in his characterisation of what was really uncontroversial facts as to how these 62 investors ended up all invested in Gibraltar.
That's the point, isn't it? These are uncontroversial facts.
Yes.
It is really the judge's evaluation of those facts. It's
Well,
not
yes.
findings of facts by the judge, it's his evaluation of them.
Indeed. And we're not at the stage of full trial, are we? But not necessarily at this very preliminary stage, which is why the guidance from the courts as to judicial pragmatism and common sense is very important. And we say the judge has departed slightly from common sense. He starts at paragraph 4 saying, this is how it happened. But by paragraph 72 he's persuaded himself it isn't within the statutory language, which we say is a surprising conclusion. I would say it's a paradigm instance of the statutory mischief that is being aimed at. And I don't plan to go through, but I think my Lady Justice Carr has picked up the point that obviously if you want to put into English legal cause of action terms, we say it's either joint tortfeasorship or principal and agent. And again, we think we have the better of the argument on that, based on the uncontroversial facts as to how these relationships commenced. In the circumstances, advertising, which is the other test I've abandoned, obviously, because I think we're so clearly within the first limb that there's no need to go down that route, and it's more difficult, so there's no evidence of a connection between advertising and these particular investors. The fourth ground of appeal, I think, I would submit that we've made good the point that certainly the European Court sees the instruments as having a degree of continuity. And whilst the threshold for consumers has been made lower in the new regulation and recast regulation, there is continuity on two key points, which is the overriding and independent public policy favouring the consumer as the weaker party, and more specifically, the width of the consumer contract gateway once it's opened, so that it includes all the difficulties that arise for the consumer in its relationship with the business party. So simply because the later EU measures made the task of the consumer easier in terms of activities directed at member states, doesn't mean we should disregard their helpful guidance on the scope of the gateway once it's opened, to include all those causes of action that arise from or inextricably linked with the contract itself. And that takes me on to the final point, the fifth ground. And we say either this is resolved by Gabriel itself, or if you accept the fourth ground, the court can look also at subsequent cases, including principally Reliant Co. And we do say, if you actually drill down into these European cases as to what kinds of measures are being relied upon by the consumer claimants, they are very similar, if not analogous to entirely, the types of measures which these consumers rely upon under our Domestic Financial Services and Markets Act to protect them in the field of pensions and investments. And however the causes of action are expressed, whether they're statutory or tortious, they arise out of the arrangement or the agreement between Castle and these investors. First, the Section 27, the second ground of claim in the particulars of claim, is about setting aside the agreement altogether. It's about getting this money back into the UK. That is what the gist of this claim is. It's reversing this agreement. That couldn't be any more inextricably linked to the agreement that was made to transfer the money out to an overseas scheme. We're saying, no, that must be reversed on the basis of our domestic legislation. The tortious claims in my submission are also inextricably linked. They are about the pre-contractual conduct of Castle and its UK intermediary or intermediaries. The joint venture with Montague Smythe and potentially other firms who were mentioned is linked to it. But the one theme throughout all the investors' cases, Montague Smythe, its actions are clearly, we would submit, tortious, and we say there is sufficient for an English common design. We have the better of the argument that that is a piece of pre-contractual conduct about a product provider using UK-based intermediaries to get in business from the UK into its pension schemes. No, I said 10 minutes, it's been 20, so I'm going to pause there unless your ladyships, any of you have any questions. I'm grateful.
Thank you very much. So, Mr. Hart. Oh, sorry, Mr. Street. Do you follow? Mr. Streer. Steer. Sorry. Mr. Hart.
Thank you, my lady. I will address the grounds of appeal, sticking fairly faithfully to the quarter of my skeleton argument, which is to say numerically, with one exception. And it's really because I just want to clear some thickets, and that's around ground 4. I have 2 submissions to make in respect to ground 4, and hopefully they won't be taken to deliver anecdotally. But But the first is that the judge was following absolutely what the statutory scheme says he should have regard to. And the second, and rather more important one, and as I say, I hope this doesn't sound too glib, ground four was all something of a storm in a teacup, given the cases upon which my learned friend says the judge failed to have regard to are not cases that in fact move the argument, and it's not true to say that the judge didn't have regard to them. He said he wasn't assisted by them, having considered them. So if I can deal with the first of those submissions. And this really goes to the heart of the anomalous nature of this jurisdiction question, which is that the relevance of the Brussels Convention to the question that the learned judge had to deal with is entirely a creature of statute. And as my learned friend explained, neither Gibraltar is not a high contracting party to the convention or the regulation. The only reason the jurisdiction is allocated as between England and Wales and Gibraltar is because the UK legislature has determined that that is the reference instrument. And they could have chosen anything. They could have chosen the Lugano Convention. More logically, they may have updated, they could have updated the reference instrument to the Brussels regulation or the Brussels recast regulation. And one should be slow to assume that the legislature has had an oversight here, because of course the 1982 Act has been substantially redrafted very recently.
So the statute you're referring to is what, section 39?
Section 39, but the whole of the 1982 the judgment, allocation of the jurisdiction questions has obviously had to have been redrafted in light of the departure from the EU. Yep. So there's been a major redrafting exercise of that. And also, the relevant order in council has been amended to take account of changes of Brexit. So the legislature has had its eye over this arrangement very recently. And it hasn't, for instance, updated to use the Brussels regulation or the recast, and it hasn't adopted the bespoke UK scheme that has now been established for consumer contract questions on jurisdictional questions, which is in the bundle.
Well, the Article 17 point.
Well, because the Brussels regulation doesn't apply in the UK.
Yes. So what are you referring to?
So what I'm referring to is that there is now a UK scheme that looks very similar to Article 17. Which is
it, is my question.
Sorry?
Which is it?
My apologies. It is in the bundle.
Is it section 15A to E?
Yes, thank you so much.
I see.
So none of those, we are in the Brussels Convention. And if I might ask...
But Mr. Macur says, well, that's fine. He's not relying on he's not relying on the different wording. He's relying on the continuance of a theme.
And I'll come to precisely that point now.
And you say that wasn't, well, if it's a continuance, it doesn't really add much. But is he wrong about that? That there's
well,
a continuing theme?
If I can ask your Lordship to turn up page 11 of the authorities bundle, and this is the Gibraltar order itself. And to make good my first point, Article 2 of the order, that's page 12, applies certain provisions of the 1968 Convention.
Yes.
And then on the next page, 13, Article 4 directs what those who have to interpret the 1968 Convention within the context of allocation of jurisdiction between Gibraltar and
you're saying that's exclusive, are you?
I'm not saying that is exclusive, but I'll come on to say what I say it means. But what it says is that regard should be had to the relevant principles laid down by the court in connection with the 1968 Convention. And that plainly includes, right up to IP completion date, that plainly includes later cases that say how the 1968 Convention should be interpreted. But I stop short of accepting that it means that there is much to be had from what is said in relation to what successor instruments mean. Now, even if I'm wrong on this, let me come on to my second point, which is what the judge actually said on this point. If I ask the court to turn to the judgment, paragraph 64 in the judgment, and that's page 61 of the foreword. It's 64 subparagraph 1. The learned judge said the decisions in Petrikova and Reliant Code do not assist in my decision upon the interpretation and potential application of Articles 2, 5, and 13 of the 68 Convention. Neither is a decision within the scope of Article 4.1a, Gibraltar, which I've just taken ladyship's to. That neither of them bears upon the argument over Article 13 is obvious from the difference in language between Article 13a and Article 17c of the Brussels recast, with its language of commercial or professional activities directed to the member state of the consumer's domicile. I mean, the point that he's making, the learned judge is making there, is that the language is different in certain respects. So what he won't be assisted by is judicial interpretation by the CJEU on different language, which was considered, reading on, was considered by the CJEU in Petrikova at 39 and Reliant Co at 45. Likewise, the decision upon the fourth question in Reliant Co, which my learned friend took to you this morning, paragraphs 58 to 73, upon which Mr. McNeill, King's Counsel, relied in saying that cautious claims against Castle were, to use the language of the CJEU, indissociably linked with the contractual ones, was clearly directed to the scope of the provisions of Article 17 of the Brussels recast. In saying that, I recognise the CJEU relied in part upon the decision in Gabriel of 56 to 57 in addressing that fourth question. Now, my fundamental submission is that when the learned judge goes on in the remainder of paragraph 64 to describe the law and relying upon what is said in Gabriel, he is right to say, at subparagraph 2, upon which the CJEU later relied in Reliant Co. So he wasn't rejecting Reliant Co. He just felt that Reliant Co. didn't particularly assist him any greater than what the CJEU had already said in Gabriel. That's well within the discretion of a judge to consider the various authorities and find, much to the misfortune of those on this side of the room, that not every authority put forward assists the judge. The point on Petrikova, I think, is even more stark, which is that I'm still not entirely sure what it is that Petrikova is relied upon, and I don't think the learned judge was. I mean, it didn't seem to raise, at the first instance, a point that was in fact an issue between the parties. And I didn't hear anything today to suggest why he should have had regard, or the learned judge should have had regard to Petrikova. So this is why I say, hopefully not too politically, it's a bit of a storm in the teacup, because the judge did look at the CJEU authorities, was assisted by some, but not by others. Now we'll get on to the nub of the matter, which is what does indissociably linked mean momentarily when I'm dealing with the grounds. But I just want to deal with this point on ground 4, which is that I simply don't accept the judge was in error in turning a blind eye to judgments, relevant judgments, because he didn't turn a blind eye to them, he wasn't assisted by them. And that's a rather different thing. That's all I really had to say on ground 4.
And you don't need to deal with ground 3.
And very gratefully, I don't need to deal with
Mr.
ground 3.
McNeill said that he's not pushing that.
Yes.
So it's 1, 2, and 5 that we need you now to turn to.
Thank you, Melanie. Dealing then first with ground 1.
Yeah.
My starting point is, if I may, take the court back to what the Brussels Convention says, and then try to develop upon what the learned judge says about it in the judgment, and then apply that to the pleaded claims. Dealing then first with the 1968 Convention. Much was said this morning by my learned friend. There is a important public policy concern that should be driving the court, that of consumer protection. And I absolutely accept that consumer protection is an important public policy consideration for the European legislators. But it is a balance of public policy considerations. It is also true to say that the architecture of the Convention makes absolutely clear that the general rule for other public policy reasons is that defendants should be entitled to be sued in their own domicile. It is also true to say that there are special jurisdictions that apply to particular situations which derogate from that general rule. And there's a general EU law principle, which with this court I'm sure is absolutely familiar. There is a statutory construction rule that where one derogates from a general rule, one must must interpret the derogation strictly. That in international law concepts could be described as lex generalis versus lex specialis, but it is also a pervasive theme of EU law statutory interpretation. And that is how the balancing works. I think it's Professor Pender that described the architecture of the Brussels and the Rome Convention as a waterfall of decision trees. That one starts at the top, and you ask a series of questions and you finally get to your answer. But that as each time you move away from the starting point, you have to interpret the derogation strictly. The starting point then is Article 5. And I say it as the starting point because in cases that my learned friend has already taken the court to, it is said consistently and repeatedly that in order to bring yourself within Article 13, one must first bring oneself within Article 5.
I don't understand that. I struggle with that. I saw that in your skeleton, and you need to take me to chapter and verse on why that is the case.
Of course. If I can take you to Cal Felix first, and that's at
95.
Thank you. It's at 95, and it's paragraph 17 of the judgment, which is at 106. Actually, I've given you a wrong reference there. I do apologize. It's in fact
15.
Yes.
Not sure.
No, it isn't. I think it's, I'm taking you to the wrong case, unfortunately. I think our starting point is in Gabriel, where it is said. I do apologize.
35.
Yes.
Necessary. I just so.
Yes, starting at paragraph 34.
Can I have a page, please?
It's a page 129.
Thank you.
And if I might invite the court to read paragraph 34 to 36. Now,
what's the status of this judgment?
Now, in the peculiar way in which CJEU judgments are written, in the gloriously repetitive manner, these paragraphs are referred to again and again and again when the issue arises. We're well familiar that CJEU judgments are not written like common law judgments. They largely restate and repeat. What has been said
you understand
before.
where I'm coming from? If you just read the structure, and I mean, we can talk about waterfalls and all the rest of it, but there's nothing, to my mind, that makes Article 5 a gateway to Article 13. To my mind, speaking just without having heard your full submissions on this, I don't understand why consumer contracts, Article 13, isn't a self-standing provision, because the articles are all standalone. The derogation from the general rule in Article 2 is specifically provided for. The rules set out in Section 2 to 6. If you're a consumer contract and you meet the requirements of Article 13, then jurisdiction is identified in accordance with Article 14. and I don't, just help me why one would say.
Do you see what I'm
not sure it makes any difference.
I understand the search for reasoning. I am limited, I'm afraid,
But if you
by what
look
the
at
CJEU has chosen to say.
If you look at paragraph 32, what it does say is, and I'm looking at the final lines of that paragraph, without, however, obtaining payment of that financial benefit, are contractual in nature in the sense contemplated in Articles 5.1 or 13.3 of the Brussels Convention, or relating to tort, delict, or quasi-delict within the meaning of Article 5.3. So it's giving an either or there, isn't it, Mr. Hart?
I don't believe it is, because of what the judgment then goes on to say at paragraph 35 and 36. And it is paragraph 35 and 36, which I'll endeavour to show, has been adopted and repeated in subsequent CJEU judgments. I confess entirely that the CJEU has not provided a reasoned explanation for why they feel that Article 13 is a lex specialis in relation to Article 5.1. I will say that the Slosser report treats it in the same way.
What says you've got to go through...
Treats it as a lex specialis to Article 5.1. But more importantly, of course...
Sorry, it's my fault. Treats what? Treats Article 13 as a what?
As a derogation from, or lex specialis
from Article 5.
Okay, so paragraph 36, as you say, says, as Article 13 of the Brussels Convention thus constitutes a lex specialis in relation to Article 5.1 thereof, it is first of all necessary to determine whether an action having the characteristics set out in the question referred for a preliminary ruling, as reformulated, can fall within the scope of the former of those two provisions.
Is that Article 13 or Article 5?
Well, that would seem from the construction of the paragraph to be Article 13.
Yeah.
Former is a reference to Article 5.1 because it comes earlier in
I
the
see.
convention.
So it's not relating to the paragraph itself, but the former of the two
Yes.
in the convention.
Yes.
Yeah.
Now that is, as I say, that is.
It just isn't. What does it add?
If I can put it in these, terms at least, because this is, it's sort of, I think it's an important general submission.
And I will be quiet. But then also, why wouldn't you say in Article 13 without prejudice to the provisions of point 5.1? Oh, I don't know. Anyway, all right. Your headline is.
I suppose my headline is, brutal as it may sound, the CJEU have said that one must do this when interpreting Article 13.1, and the learned judge has no discretion to depart from that. He is bound to apply, I've already shown you in Article 4 of the order, he's obliged to apply the CJEU jurisprudence on the principles of interpretation.
Okay, so he looks at this, he says, right, I've got to look at Article 5.1, I've got to ask myself whether it's a matter relating to a contract. And if it is, then I go on to say, are these proceedings concerning a contract? So you sort of ask yourself the same question twice.
Yes.
Right.
So 5.1 is in relation to individual contracts of employment.
No.
So I'm on page 7. So sorry.
Article 5.1, page 7.
Yes. So a person domiciled in a contracting state may, in another contracting state, be sued in matters relating to a contract in the courts for the place of performance of the obligation in question, in matters relating to individual contracts of employment. This place is that where the employee habitually carries out his work. So this is where the employment comes in, doesn't it? That's on my page 7 anyway.
Yes,
So it's
that
general
is
contracts and then employment contracts separately.
Yes. Yes.
And then maintenance and tort.
Yes, it's infelicitously
Anyway,
drafted paragraph, but it does go.
You say one has to go through this exercise.
Yes, and one does have to go through this exercise, and I think it speaks to a general point. Of course, the EU legislature had every opportunity to create a, as my learned friend calls it, one-stop shop for consumer issues. So that wherever a business and a consumer is in conflict, there will be a special rule of jurisdiction. It hasn't done that, and it's certainly not done it in the Brussels Convention. And it is perhaps well worth recalling that the Brussels Convention changes and consolidates, or has changed and consolidated over time. And so that the provision that Article 13 has become started off only in relation to credit loans, consumer credit. Around the time that the UK acceded to the EU, it developed into what is there now. But what hasn't happened, and what didn't happen during the lifetime of the 1968 Convention, is simply a general provision saying this is how all consumer.
And forgive me, I don't want to sound overexcited, but you said that there's one of the reports also says you've got to go through Article 5 before you get.
I believe so.
If you could give me the reference to that, and
Yes,
whilst you're looking for it, I just make the observation as well that Articles 13 and Articles 5 are in two completely different sections. Anyway, if that's what they.
50.
Well, that is of some importance, isn't it? Because
Yes.
Section 2 is identified as special jurisdiction, whereas Section 3, which contains Section 4, is quite specific, jurisdiction over consumer contracts.
Anyway, others have obviously.
Sorry, I
Don't worry, but at some stage.
If I might come back to that, and if I also might come back to the assistance of the court with the subsequent references in CJEU jurisprudence to this particular set of paragraphs in Gabriel. I think it might assist the court to see.
Are we bound by all of this?
Yes, yeah. because of order Article 4 of the Gibraltar order.
Yeah, thank you.
As was the learned judge.
All right, so bear with me, Mr. Hart. So Article 5.1, which you say we've got to look at before we look at Article 13. A person domiciled in a contracting state may, in another contracting state, be sued. So Castle may be sued in matters relating to a contract in the course or the place of performance of the obligation in question.
Yes.
Right. And then we go to Article 13, and this particular contract is consumer contract, sorry, Mr. McNeil says. And so if place of performance is where we look, you'd say that place of performance is or is not in the UK.
I don't know. I don't go as far as that, my lady. I go only so far as what the CJU have indicated, which is that each time that they have applied the sense in which they have interpreted that to mean is that you have to first show that it is arising out of a contract.
Well, you have to do the same in Article 13?
Well, if I may, because the Calfelis shows that the structure of Article 5, and this is the point the learned judge followed, Article 5, the subparagraphs of Article 5 are mutually exclusive. And that's what Calfelis says, is that you cannot be in both Article 5.3 and Article 5.1 at the same time. And so I don't accept my learned friend's submission that you are simply able, when you're in Article 13, to look at anything. And in fact, cases can be took to you, but you're simply allowed to look at any claim, as long as there's a business relationship between the consumer and the business. What is the case, and I fully accept, is that what is meant by a contract is afforded a independent, autonomous definition. And that's what you see happening in Gabriel. And you see what's happening actually in Reliant Go. What that means is that it's not, The phrase the judge used is taxonomic. It's not taxonomic to the national system. One doesn't say, is this a claiming contract as a matter of lex fori. What you determine is, does this arise out of, does the claim in question arise out of, or is it inextricably linked, or is it indissociably linked to a contract for a
Mr.
service?
Hart, I'm sorry, we're just going all over the shop now, so far as I'm concerned. Are you accepting that there was a contract between Castle and these claimants? Is that an issue? Because
yes.
this morning we spent a lot of time talking about agreement, the terminology of contracts and all the rest of it. But now we've gone into dissociable links. So, I mean, it would certainly help me if we can stick with one line of thought.
I fully understand, my lady, but the question, the issue with which the learned judge was seized was, do the claims arise out of a contract, consumer contract for services? And the learned judge concluded they did not, because they arose out of.
So before you get to consumer services, do you accept that there was a contract?
I accept there was a contract. I don't accept that the claims arise out of that.
No. So, but first and foremost, you accept that there was a contract.
Yes,
right. Okay. So that presumably would get us through 5.1 anyway, wouldn't it? And then we go to see whether it's a consumer contract for the provision of services.
Yes, ma'am.
Right. Thank you. So I'm very sorry to be so slow about this, but now I've got that. So the agreement is established.
Can you tell me what agreement you accept? Because it may be a very sensible, sure it is a very sensible concession, but it's not something that I picked up from your helpful skeleton.
I'm very happy to do my. Is it?
Do you accept as it was put?
No. Can I possibly take this in a very slightly different order, and I'll get to answer your question very quickly. So I just wanted to take the court back to the duties that are alleged, because I do feel it is important when they're trying to determine what contract for services, if there was a contract for services,
We're quite happy for you to do that, I can assure you, Mr. Hart, but I, like my Lady Justice Carr, did understand that you were actually questioning, as did the judge, whether or not there was any contract, because the judgment seems to suggest that this is all from the deed, from the trustee. And Mr. McNeil this morning has taken quite some time to emphasise to us the two-horse running administrator and trustee, and the administrator being the important issue in terms of the contract. Now, if we've got beyond the stage of contract, so we don't need to look at 5.1 anymore, even on your submission that you've got to establish a 5.1 contract to get to Article 13, we then get to contract for services, which you're going to come on to now, and then we've got to go to the strict invitation. Is that right?
Not quite, my lady. And maybe I expressed myself badly. The point that I was trying to make in relation to...
No, it would be me, not you.
But the point I was trying to make in respect of Calfaris is the sublims of Article 5 are mutually excluding. And so and that includes Article 5.6, which is that if you're being sued as a trustee.
Right, okay.
And so the argument, the conclusion that the judge came to and the submission that I made is that one doesn't get to Article 5. One doesn't get to Article 13 because one doesn't get to Article 5.1 because it's excluded on a proper understanding of the claim, because what actually is happening here is a trustee is being sued, which would mean that you would only get to Article 5.6, which is why, in fact, therefore, you never go down the road of Article 13 and the general rule remains, which is Article 2.
And are you saying that you can't have two tandem claims then?
I'm saying that you can't,
Right.
because that's what the CJEU was saying in Calfax.
Right.
There's
So
a mutual.
Mr. McNeill says, well, it's quite clear that there was an aspect of this relationship which was trustee and beneficiary. But I'm not talking about that for the moment. What I'm talking about is the relationship between Mrs. Dooley, for example, and Castle as the administrator of the scheme. That's right, isn't it, Mr. McNeill?
You
So
can't be
on
right.
that basis, he is looking at 5.1 before he goes on to say the dissociable element. 5.1, not 5.6. And the whole point of his argument is that the judge was distracted by 5.6.
My submission is that if one goes back to paragraph 110 and following, or 111 and following of the particulars of claim,
Right.
look at the duties that are alleged and the breaches that are alleged. The argument that there is this sliver of a contractual relationship outside of the trustee relationship that is the tail that wags the entire jurisdictional dog doesn't work, because when one looks
Well, let's
at
go
these
to
duties-
110 and
If
111.
I can develop that.
Yes, because,
Thank-
yes.
But I'm
thank you.
sorry, this is now going to be a bumpy afternoon, because this is not going the way that I read your skeleton, or the way that I read the judgment below, which may be entirely my fault. But it cannot be right that if a person has two separate claims, one for breach of contract and one for breach of trust, that Article 5 makes that impossible. They are mutually exclusive. If you have two separate claims for two separate causes of action, you must be able to run them both. And as I understood you to be saying, the law is that under Article 5 you can only have one or the other. That can't be right.
No, that's and that's not what and that's not what I'm saying. I'm sorry to come across that way. What I'm saying is that one looks at the capacity in which the person is acting and performing the services that are said to be a breach of contract. One has to look at the actual duties and the duties that were breached and ask the question, are they really a breach of contract, or are these duties arising out of the trust deed and the rules?
Right, so
Because if it is the latter, then you're not in Article 5.1 and therefore you're not into Article 13.
So you're accepting that there exists a contract between each of the claimants and Castle?
Yes. Yes, maybe.
but what you're saying is that the thrust of this claim, which you're going to take us to now, really demonstrates that we are deed rather than contract.
Yeah, yes, maybe.
Yes, so
And that, I apologise if that doesn't come across my scatterment. That was the argument that I submitted to the judge at first instance. And
It may be
that
completely
was,
my fault. But
and
that is.
that's how I read his judgment.
Mr. Hart, you blame my lady and my lady can blame me, but shall we go to 110, 111? Because it's
Yes,
Article
it's
3.
111. So it's page 99 of the core bond.
All right.
The 111 is the start of the duty, and they aren't what might call plainly distinguished pleadings. They sort of run everything together, and so perhaps it's more useful to look at the subparagraphs of 112,
Right.
where a set of specific duties are set out.
Well, no, in the first sentence of paragraph 111, quite specifically is pleaded a contract for services. And it deals with the assumption of responsibility for their financial and pension arrangements.
The task that the judge undertook was to go from the bare pleading of a contract for services, try to identify where those services are described, what these duties could fit into in terms of a set of described services.
I'm
found the
also
answer
going to
in the-
say
in
this
the
is a
trust.
fig leaf, and the pleading of contractual breach is somehow a sort of a fig leaf on which to hang jurisdiction. I am very surprised to be that anybody was being invited to go through the pleadings and say, well, it's all in there, but actually, on a proper construction of the pleadings for jurisdictional purposes, this is predominantly a trust claim, and therefore it's not a matter relating to a contract. When on the face of the document, the claim pleads causes of action pursuant to a contract of service, and by reference to a contractual duty to exercise reasonable skill and care. You say we can go through and look at the pleading and say, actually, it's all fiduciary.
Oh, one can go through the pleading, and then one can identify a document, the trust deed, that is, and the capacity of the trustee, in which all of the things that are said a duty was owed in respect of, and all of the breaches that are said to have arisen, would have been that entity acting in its capacity as trustee. The admission of members, the exercise of powers of investment, valuation on an annual basis, and so forth. So I mean, the duties are an intermediary due diligence duty and a client due diligence duty, which would attach to the admission of a member to the scheme, in my submission, the product due diligence duty, which would attach to the exercise of powers of investment, the valuation duty, which is, you've already been taken to, in the welcome letter, it was made clear that that was a duty being undertaken qua trustee. The financial crime duty.
Sorry.
Which again is in relation to the investment.
That's right. This section is all dealing with duties as pension scheme operator and or as trustee. But you've got to look at what comes before. In the circumstances, duty to act honestly, fairly, reasonably, the requirements of its contractual retainer, obligation to act honestly, fairly and reasonably. And then you've got these additional ones in particular. But what are we to do with the contractual duties and the contractual breaches pleaded at 115? Do we just ignore them?
It's not a question of ignoring them. It is when one looks at the particulars of breach. Again, they tag back to the specifically pleaded duties. And they are
which
all
are said to be, amongst other things, contractual.
The difficulty is that, unlike in the Adamson options case, where there was a scheme administrator terms and conditions for a separate entity that included a description of the services that they would be undertaking, there's none of that here. I mean, my own friend took relationships to the terms of business and the questionnaire. As the judge found, they are secular and meaningless. The one thing they don't do.
Well, he didn't. He recorded your submission that they were circular and meaningless. His reasoning was limited to saying that services, and it's no disrespect, no criticism. He just said certain services are not specified.
Yes. The services just aren't described. But the exercise, the doing of things into which you could arguably seek to locate those duties are to be found in the trust deed, as is remuneration. And it is. I mean, I don't want to jump around all over the place, but my learned friend took relationships to clause 12.2 of the trust deed earlier, which is a clear remuneration clause. It referred to a published scale of charges, which the learned judge found was a reference to the fee schedule. Now, it was said in my learned friend's skeleton argument, and I think slightly orally today, that the fee schedule was attached to the personal details form. That can't be right, because the personal details form in evidence is dated September 2014, and the fee schedule that is in evidence is dated October 2015. There, in fact, wasn't any evidence before the judge or this court that although the personal details form says I accept the fees in the attached fee schedule, that there was in fact any fee schedule attached. I mean, that is not evidence that's before.
Sorry, I thought the terms and conditions the fee schedule was attached?
There's no evidence that it was. I mean, it's in the bundle as if it was attached, but it can't be because it's 13 months, stated 13 months later.
Right.
So I think there's been a melding together of various things that are available in pre-action disclosure.
Okay. So.
And this is a point the judge was alive to as well, because he does make the point, I think, in 64, in paragraph 64 of his, maybe 68, sorry. He makes the point, I'll get it, that the fee schedule was dated October 2015.
I haven't got the paragraph, but I'm sure it's in there somewhere, is it?
Yeah,
Don't worry, I didn't waste time on it.
okay. I'll come again back with that. So my central submission is that if one looks at the personal details form and Appendix 2, one ends up simply going around in circles, not identifying any services that could plausibly relate to these proceedings and the claims being made in these proceedings.
Just help me, but pause there, do you mind? Sorry if I'm being Julia, okay with me. Thank you. So what do you say the agreement was? That you accepted this, what was it? What were the services to be provided under the agreement?
The one thing in the personal details form, which my friend has already pointed out, which was execution of the deed of adherence.
Execution of the deed?
Of the deed of adherence.
So do you accept
and
to
also
exercise reasonable skill and care in bringing about the pension transfer from UK to Gibraltar?
No, reasonable skill and care in adhering to the deed. Just simply doing the administrative task of executing the deed of adherence for the relevant claimant, rather than have them do it personally. And
do we see that in your submission below or in your submission before us? Just so I can find where we are in your skeleton.
I don't think I do.
The thrust of the judgment is there simply wasn't a contract because there were no services identified.
I think it comes back. I think it possibly. I hope it comes back to the same point, which is the submissions that I was making below was that one starts with what are the claims that are being made. And we spent a lot of time at first instance going through the personal claims and what the personal claims were, and also that the one document that had been identified, which was Appendix 2, in terms of conditions of business, didn't identify services because relevant services because they were they're simply not defined or mentioned or described in any form or fashion.
Your definition of the services to be provided, the limited nature, doesn't really work, does it, with clauses 3 or 6? 9.
The difficulty and the reason for that, I would submit, is that this is a plainly standard form set of terms and conditions of business that apply to a whole range of different circumstances. They, for instance, envisage that there would be an engagement letter that sets out the basis of our contract. And what in fact there is there's a personal details form that just doesn't.
Right. So have I understood your headline position as follows? You say this is, although breach of contract is pleaded, when you look at the duties in paragraph 112 and the breaches in 115, this is not in fact a matter relating to a contract. For the purpose of Article 5.1, it is a matter related. It is an Article 5.6 matter.
Yes.
And because we don't get through Article 5.1, we don't get to Article 13.
Yes.
Right. Thank you.
That is, I mean, in the interest of time, those are my submissions on ground 1, and I was going to move on to ground 2.
Can you? I'm sorry to. Can you take us to any authority where there have been claims that are not on their face as acceptable to strike at, or where a court on a jurisdiction hearing has been taken through lengthy particular claim and said, well, I see what it says, but actually the substance of it is not contract or tort. It's all about the deeds.
No, my lady, but my submission is that is the proper approach to take when dealing with the issue of whether something falls within Article 5 or Article 13, precisely because one's not engaged in that taxonomic exercise of what, according to the national law, is being pleaded. Is it under the species of contractual claim or tort claim, etc. One looks at the substance of the matter, and one tries to determine what the nature of the proceedings are. So I say it's an approach that is consonant with the approach that the CJU wishes to be taken in respect of the Brussels Convention. But I don't. It's similar to your question was the first answer, which is no, I don't have an authority.
But you're saying that my lady is right in that effectively you and the judge were saying this reference to a contract, it is a manipulation.
Yes. I think earlier I said a tail wagging the dog, but it's more than that. It's actually just a figure.
And you're just really warning us that we've got to be careful that just because there is a contract doesn't mean that this case is really about a contract.
Precisely, my lady, I think you posed earlier on the scenario of Mrs. Dooley tripping up and falling over on the way into Montague Smith, which was obviously an extreme example of where one end of the spectrum starts, and at the other end of the spectrum one has it arising out of or relating to the contract. And I say that's the right approach to take. One has to accept that simply just saying this is a contractual claim isn't enough. One has to go in and work out, well, are the allegations being made allegations of wrongdoing by Custom as trustee, or are they wrongdoings in the provision of a set of services?
Yes, you're saying Mr. McNeill is going backwards instead of forwards.
Yes.
Yes, saying that because we've got these claims, we can get back eventually to a contract.
Yes, my lady. That's precisely it, and that's what that is the thrust of my submission.
Yeah, well, I'm thank you for that.
I'm conscious of the time, so if I can.
Yes, I was mistaken that I thought you were denying that there was a contract at all, but I now see how you're putting your case.
If I can then turn to the question of specific invitation.
So this is ground 3 now. Ground 2.
Ground 2.
Sorry.
Indeed, my lady. The starting point is, and my left hand has already taken the court to what is actually said of Article 13. 3A. I think my learned friend made a submission, possibly at the intervention of your ladyships, that on a plain reading of the text, it didn't have to be it didn't have to be the trader or somebody on behalf of the trader making the specific invitation. I'm not sure that can be right in light of what has been said in the expert report and in subsequent jurisprudence, because that's not the way that this provision has been interpreted in cases and expert reports that this court has to have regard to. Because those have approached it from the perspective of that it either has to be a specific invitation by the trader, or, depending on the language used, middleman or agent. So my submission would be, if the same question was being posed to me, my submission would be the specific invitation has to come on behalf of, at the very least, on behalf of the trader. My second submission is as to what a specific invitation needs to be. And if, in this respect, I can invite the court to turn up the two special reports. And we start with the Slosser report, which begins at page 354 of the authority manual. And it is a paragraph 158, page 401, going over to 402. Now, as at the outset of my submissions, I draw attention to, the learned judge was required to have regard to this report. And as my learned friend pointed out, and I just want to make good, what is said in this report, to some extent, is go and have a look at the report on in the Rome Convention, and incorporates what is said by Professor Giuliano on the Rome Convention as being relevant. Because
Sorry, where are we?
this is page 402, the bottom of the second paragraph in the first column, just above the 3. So it says, further details of what is meant by a specific invitation or advertising in the state of the consumer's domicile, and by the steps necessary for the contract. See the report currently being drawn up by Professor Giuliano.
And are we going there now?
And that's why I'm going to take your ladyship to what it says. Just before I do, the only point that I wanted to make in respect of what is said here is the policy principle behind why this requirement is in place, which is that there was a requirement being placed that there be sufficient connection with the state of the domicile. So that is what both 13A and B are directed to. And they are only in relation to contracts for services. The reason for that is because contract for services was a novel expansion of Article 13. Article 13, as I earlier submitted, started off as being simply about consumer credit. It then got expanded in line with the recognition of the importance of consumer protection to include contracts for services, but with what is given with the one hand is slightly taken away with the other, because there is, as I said at the outset, a balancing of competing public policy considerations. So these are restrictions on the breadth of Article 13.3. And that is how they are intended to operate. If I can invite the court to look, therefore, at the Giuliano report, and so it's starting at 457, page 457. There are this section of the report starts with Article 5, certain consumer contracts. In relation to this point on specific invitation, it starts at the bottom of page 457 on the second column. The first indent should say relates to situations where the trader has taken steps. Taking steps to market his goods or services in the country where the consumer resides.
Sorry, bottom of page 457.
We start at the bottom of page 457, second column. First words are the first indent.
On the right-hand side.
Yes, and there's relates, I see.
That should be
No,
related.
thank you.
Again, if I can invite the court to just to read from there over the page to the bottom of the first paragraph on the left-hand side. There are 2 points that I wish to make in terms of what I say this commentary elucidates in terms of the meaning of specific invitation. The first is what is the nature of the invitation, and that is that it is you are making a business proposal. You are making an invitation to use the services of the trader. And the second one is that whatever a plain reading of the article might invite, it's quite clear that it has been interpreted as meaning either by the trader themselves or through a middleman. And when one comes on to the CJU cases that refer to this commentary and apply it to facts, there is reference to agents. And my learned friend, although he rather disclaimed I don't think he quite described it as the parochial definition of agency within English law, his grounds of appeal certainly are advanced on the basis that what the role of Montague Smith was as either a joint venture partner or agent of Castle as principal. If I may, on the question of joint venture, in my submission, joint venture isn't enough. I mean, what the critical phrase that I would alight on is that if it's not being a business proposal being made by the trader but by a middleman, that middleman must be doing it on behalf of the trader. So it is, in simple parlance, an agency relationship. It is doing it for the trader. So I said joint ventureship, which can work in two directions, isn't enough. I mean, not least because, certainly in terms of the pleaded case, what is said to be the common, what is said to attach the liability for joint tortfeasorship against Castle is their awareness of what Montague Smith was doing. It's a knowledge-based joint tortfeasorship. So that is not, in my submission, enough on which to bring yourself within Article 13.3. Which brings me on then to the question of...
I'm so sorry, I missed that argument. Can you... So joint venture would require Castle to have knowledge of Montague Smith's wrongdoing.
Yes, this is what's this is if I can take that's how it's pleaded. Is my time. So I can go. Please.
Yeah, and what are you saying about that? So
what I'm saying about this that doesn't.
If it was correct as pleaded, would that then fall into Professor Giuliano's encapsulation?
No, I'm saying it wouldn't. Knowing that somebody else is doing wrong doesn't mean that the proposals they're making are on your behalf.
Right.
Or they're making a specific invitation that somebody should use your services on your behalf. It's quite another thing. Although joint venture, I mean, I can give to the court the references. I'm not going to take the court. Joint venture is pleaded at paragraph 36 through. I think primarily 38. 36 to 40. In terms then of joint tortfeasorship, that is pleaded starting at paragraph 91, and it's at paragraph 94. As I say, I'm not inviting the court's attorneys up now, but it's paragraph 94 of the particulars of claim. The allegation against Castle was made, which is that it knew or ought to have known that the conduct of Montague Smith above was negligent. And so that sort of joint tortfeasorship.
Yeah,
It
so
has nothing to do with whether you're making a specific invitation on behalf of somebody or not. And so I think we're solidly in the question of agency.
Can I just go slightly back and
Yes.
really a simplistic question? Are you in any way disputing the assertion made in what I accept was a post-contractual letter that Castle were accepting that Montague Smith were their introducers?
I am not. I entirely accept that the welcome letter describes them as an introducer. What I'm not accepting is that there was an introducer agreement in between them where Montague Smith had been appointed introducer or was appointed to act as agent of.
Well, we don't know. We haven't been told, and so we have to decide who has the better of the argument on the basis of what we do know. Clearly the burden is on the pensioners, but you've chosen not to disclose the arrangements with Montague. We have to decide what to make of the evidence as a whole, and that includes the words, is it just introducer?
It's introducer.
Just our introducer or your introducer?
I think I wanted to.
It is to contact
Your
and
introducer.
it comes from Castle.
Your
Yeah.
introducer. What I wanted to do, Melanie, is take your leaderships to the evidence, which is primarily the letter of response. And I feel that I am bound to make clear what it is that we don't accept, which is being described as being common ground or uncontested. And in terms of burdens and what we have or haven't done or could have done, I don't want to go in any particular length into this point because I'm sure the leaderships are not particularly interested in the spat between my learned friend and I as to who was most surprised at the hearing below. But as I had in my skeleton argument explained the circumstances that arose and what happened prior to the hearing. The understanding until I had received my learned friend's skeleton argument that the position being advanced was that there had been advertising and that was on the basis of 13.3 was established and that was set out in their letter of claim. And that was also referred to in the particulars of claim. And so it generally did come as a surprise that they were advancing a specific invitation argument until I received the skeleton argument. And I'm that much more surprised, but grateful. So ground 3 has been abandoned today, and it's no longer being suggested that advertising is what got the jurisdictional hook.
Yeah, so I mean, nobody's throwing any blame anywhere about this.
But it just surprised me when I'm dealing with the letter of response.
Right.
Just make clear what it is that we don't accept.
Right, so
terms of the
introducer, you
Yes.
accept the term as used in that letter.
Yes.
And Mr. McNeil would say introducer is the equivalent of an agent. And you're saying that if an agent makes the offer on behalf of the principal, then that could be a specific invitation.
I accept all of that. What I don't accept is 2 points.
Right.
Firstly, that there was any evidence before the learned judge that a business proposal had been made on behalf of the defendant, of the respondent. I say that the emails don't show that because they're simply and no more than a slice in time. They might look as if they are an invitation, but because you don't know what came before, it's simply not plausible in my submission to say that those are specific limitations. And I add to those 2 points. Firstly, not only is the burden on the claimants to show a specific invitation was made, but the point that the learned judge made, which is that it was uniquely within their gift to be able to say how these things came about. And they could have, I mean, I know my learned friend suggests that nobody wanted 60 witness statements, but there's a long distance between 60 witness statements and Mr. Wilson explaining in that, I think it's what my learned friend slightly clarifies that, this is generally how the invitations were made on behalf of Castle. And that's not.
What does Mr. Wilson say about that?
I think, in deference to Mr. Wilson, he wasn't making submissions on
No,
specific
but what does
invitation
Mr.
because he's
Wilson
probably
say
seen all of the requests that witness statements don't make submissions. But if I can turn up what he did.
But let's see if there is any evidence, even hearsay evidence, on the point of specific invitation.
So it's
Supplementary page 70.
17, thank you.
70, I think.
78, thank you.
No, 70.
70.
Seven. Oh, sorry, no, on the relevant passage, yes, starts at 66.
This is the passage, that's right.
Yeah.
In all of the claimants' cases, the QROPS and underlying investments were principally promoted and recommended to them. Promoted to them by Montague Smith.
But there's no further detail.
What does promoted mean?
The learned judge felt that this was insufficient evidence of a specific invitation.
He didn't look at this. He didn't consider on the face of it, in this part of his reasoning, this evidence at all.
Well,
he refers to the 2nd of June letter, but not to the evidence. To that evidence.
He referred to an exhibit to the witness statement rather than the witness statement at all. I would hesitate to suggest that he hadn't considered the witness statement. I accept he didn't flesh out having considered it and rejected it in his judgment. But I don't recall him being taken to this particular paragraph in the first instance. But I'm going to correct me if I'm wrong with that.
And Mr. Hart, is this sufficient? Promoted and recommended as a specific invitation?
It is not unless I say it isn't. I say that you wish to see evidence that a proposal to use the services of Castle is what you are looking for, and I don't think that is what Mr. Wilson is saying. But if I'm wrong on that, then I'd rely on the arguments that I'm about to make in relation to what the letter of response says in terms of what the relationship was between Montague Smith and.
All right, so your response to ground 5 is your alternative. If everybody's against you on everything else,
yes,
you then go back to the relationship. But just looking at paragraph 26 at the moment, in the case of all the claimants, and we're at the jurisdictional stage now, we're not looking for evidence to establish the balance of probabilities as to whether or not this did or didn't happen, but whether or not there is an evidential basis, potentially. Saying were principally promoted and recommended does seem to be consistent with a specific invitation to use Castle. Subject to your further arguments as to whether or not the relationship was sufficiently proximate.
I hear what your ladyship
I'm
says.
just. It's a question. Sorry.
No, well, that's
a question mark at the end of it.
I respectfully submit that it doesn't say that what is being promoted is the use of the QROPS as a vehicle. I think that is different.
In general.
Yes, I think that's different
Right.
to being promoting Castle's services.
So the QROPS and the underlying investment.
Well, the underlying investment wouldn't be in relation to on the facts. The underlying investment wouldn't be in relation to something being provided by Castle, because these are essentially the investments are being proposed by the claimants themselves.
QROPS are defined, aren't they, as the Gibraltar Castle Trust?
Oh, then I apologise, and maybe
No, don't worry at all.
my submission
No, don't worry.
is
You're
not particularly strong.
fielding a lot of questions, but para 14 of Mr. Wilson's statement identifies the crops as being the castle crops.
Then my answer maybe is not very good, but I still stand on the general submission that one is looking for evidence of when the proposals were made, because you have to show that they're made before obviously the conclusion of a contract, that they are proposals to use Castle. I appreciate it's only at the jurisdictional stage, but this is, in my submission, insufficient evidence to establish a specific invitation. And then, but it may be a useful time for me to come on to my second point, which is whether it was or not on behalf of Castle.
I'm sorry to interrupt you, Mr.
Yes.
Hart, and by all means come back to it. It's simply that when one reads paragraph 14, there Mr. Wilson is identifying Castle as both the administrator or operator and the trustee, which, as I understand it, reflects very much the claimant's case.
But this is the claimant's witness statement.
Yeah, yes,
Oh,
thank
sorry.
you. But indeed, yes, thank you. If one then looks at page 10 and the welcome letter, as it's called, which is written by Castle, it is interesting how they describe themselves in that final sentence. They refer then, if there's a problem, don't hesitate to contact your introducer, Montague Smythe, in the first instance, or Castle Trust and Management Services Limited as your trustee and scheme administrator. So there they distinguish.
Yes, my lady. However, 2 points that I would make to that. First is scheme administrator is defined in the rules, and it is identified obviously as the same party, Castle. But when one looks at what is complained of in terms of admitting members, of making investments, exercising the power of investments with insufficient due diligence, in terms of not doing sufficient due diligence to determine whether a valuation could be made. And when one looks at the operative documents, or what I submit to the operative documents, the trust deed and the rules, those are all things for the trustee to do. It's the trustee that admits members, it is the trustee that exercises the powers of investment, it's the trustee, as it says in the welcome letter, who provides the annual valuation. It doesn't say what scheme administrator does, but more importantly, it doesn't say that those are the things that the scheme administrator does. So, I mean, it rather goes back to, as I said, my ground one submission, which is that this is a case about what the trustee on the Appellants case should have done but didn't do.
So the specific invitation point again.
Yes.
Yeah.
Thank you. My learned counsel in his skeleton makes much of, did make much of what he says was an undisputed factual context. And some say he did that orally as well. And paragraph 1 of his skeleton, I don't think it needs to be turned up, says the principal unregulated intermediary, Montague Smith, was in a commercial relationship with the respondent, which styled the intermediary as an introducer of business, and to whom it paid substantial fees and commissions based on each pension transfer it referred. And this is very much the submission that the counsel developed in paragraph 21 of his skeleton, and also orally, he says that the appellants could properly complain about the failure of Castle to disclose its commercial contract with Montague Smith, under which it was appointed as introducer of business and under which its role and remuneration were agreed. The existence of this document was admitted in its letter of response. And obviously, in making the principal and agent arguments in the skeleton, and also orally, and that is said to be what makes it absolutely clear The invitations made by Montague Smith were specific invitations within Article 13.3 because their uncontested role was as remunerated introducer, appointed under this introducer agreement. Now, I have taken instructions on this point, simply because I'm disturbed at the suggestion that my clients have withheld evidence. And I'm instructed there isn't a document, because there was no appointment of Montague Smith by the respondent as an introducer, and there was no payments for commission or fees to the respondent by the respondent to Montague Smith. And I can take you to the evidence before the learned judge that bears out what my instructions say. And if we turn to the letter of response, and I know that the report has been taken to this already, but turn to the letter of response, which starts with page 40 of the supplemental bundle. And pick up first, as my learned friend took you to, page 43, the last full paragraph, which starts, our client cannot respond. Second sentence.
Yeah, I see, page 43, yes.
Insofar as CCMS Limited is aware, for material times, Montague Smith was an aggregator and distributor of financial services products and operated through a network of independent financial advisors. And then, if we can turn on again to where my learned friend took the report, page 49. The third paragraph after the heading joint venture. As part of its ordinary business-to-business dealings, CCMS entered into referral arrangements with pension and investment managers and providers for the provision of trustee and administration services. Prior to the provision of services to the claimant, Castle was approached by Montague Smith. Montague Smith informed Castle that they were looking for a provider of pension trustee and administration services for a number of pension clients. And pausing there, the 2 points that I extract from that is that we've seen how Montague Smith was described by my instructing solicitors on behalf of Castle. What's Castle's understanding of what they were, which was an aggregator. It's not the same as that definition of pension and investment managers and providers of provision trustee administration services. Second point is that it would appear that Montague
This is that they were looking for
clients.
For my part, I know you're under pressure of time, but I'm finding this very difficult to follow. What's your short point?
My short point is that the sentence that says, it should not follow from the sentence that says that Castle entered into referral arrangements with pension and investment managers and providers in provision of trustee and administration services. But that's a reference to Montague Smith, because Montague Smith is not understood by Castle to be either of those things. The point
It's a matter of reference. I mean, why tell us what the ordinary business dealings are if what happened here was extraordinary?
It's not.
Services and terms were agreed, and that's what's not being disclosed. I mean,
Well,
very much in my lady's hands, but it seems to me that it's not, putting it colloquially, not fair to assert a negative whilst withholding the positive. This is what's missing. In due course, Montague Smith selected CTMS to provide services, and terms were agreed. And you're coming along and saying for the first time, well, there wasn't an agency agreement, but I'm not going to tell you what there was.
If that's a description of an agency agreement,
No, I'm not suggesting it is, but you are. This is what's missing. Am I right that the terms being referred to there have never been disclosed?
My instruction is that there is no document showing terms appointing Montague Smith as an introducer. And the point that I'm simply trying to make here, I was trying to get to the end of my sentence, was to say that if this is the description of an agency agreement, it's the description of appointing Castle as the agent of Montague Smith.
Right.
It can't be interpreted the other way around. I mean, it just doesn't say that. It says that in due course, Montague Smith selected Castle to provide services and terms were agreed. In terms of remuneration, the next point I just want to deal with is it was said that there was a delegation to Montague Smith.
Sorry, it was carrying on if we're going to do this exercise. Bottom of the page, it was agreed between Castle and Montague Smith that Montague Smith would carry out money laundering checks.
I'm just about to come to that.
Yeah.
That was literally where I was taking an action. So it is agreed that they would prepare the Know Your Client and Due Diligence Pack. I mean, it doesn't, just be clear, it doesn't say that they were going to undertake money laundering checks, they were going to prepare the documents. But in any event, that's not making, that's not appointing somebody as an introducer or inviting them to make a specific invitation on your behalf to anyone. That's a purely administrative task. And then turning to the question of remuneration, this is pinned upon the fee of £2,000. I mean, it's been said a number of times today, and then the skeleton argument, that Castle paid commission and fees to Montague Smith. The fee of £2,000 is pleaded in a particulars of claim, and I'm going to take the court to that. It was paid by the claimants to Montague Smith, and it's at page 58 of the particulars of, paragraph 58 of the particulars of claim. I'll get the page reference. Each of the claimants is instructed by Montague Smith to sign a pro forma boilerplate letter, typically on Montague Smith headed paper, entitled Associated Administration Fees, stating, I agree to pay Montague Smith the associated administration costs relating to assisting me with the necessary process, transferring funds from existing pension schemes to a QROPS, and help ensure compliance with the relevant pension legislation and HMRC rules that govern this type of scheme. That was an agreement between Montague Smith and its clients. There's no evidence that was a fee paid by, or commission paid by Castle, or even that Castle were involved in determining the quantum of that fee, or that there should be a fee at all. It's simply not the evidential basis for saying that there were commissions and fees paid to Montague Smith as introducer by Castle. Which brings me back to the point that I was making just before, which is that if one reads the letter of response against this, it would appear that Montague Smith hired, in colloquial terms, hired Castle to be the pension fund trustee. Not that Castle engaged Montague Smith to market or promote its services to investors in the UK. And that's why I say that the judge was correct to find that there was no specific invitation.
So Montague Smith would have had, on this basis, you're saying, no further interest in the contracts that were going to be entered into by the clients, the pensions. Once they have their £2,000, that's it.
I see no evidence for a continuing.
Well, what about the welcome letter, which says contact Montague Smith?
That I think is to be easily explained by what I said at page 49, paragraph that I took relationship to, which is that Montague Smith informed Castle they were looking for a provider of pension trustee remuneration services for a number of pension clients. That's pension clients of Montague Smith.
Sorry, I missed that. So the welcome letter says, ask us, or ask them, ask us, and it copies Montague Smith in.
Yes.
And this is into Mrs. Dooley's it's her first valuation statement. Well,
Yes.
Why would you involve Montague Smith in that?
Because these were the clients of Montague Smith. And that's what it says at page 49. These were clients of Montague Smith.
Sorry, 49 is the supplementary bundle.
But 49 is the supplementary bundle. Second but last paragraph. Montague Smith, midway through, Montague Smith informed Castle that they were looking for a provider of pension trustee and administration services for a number of pension clients. Montague Smith had pension clients and wanted someone to provide pension fund trustee services that approached Castle. That's not a specific invitation, it's the wrong way round.
I understand the argument you're
sorry.
making, Mr. Hart. Was this brought before the judge, this particular passage?
Yes.
And where do we see how he deals with it?
In the judgment,
Yes,
page
72, my lady.
it's paragraph 72. Yes.
Thank you. So if I'm wrong about that, that's the one, isn't it, that we were looking at, we started to look at. So he doesn't, in his judgment, deal with this that you're taking to us now.
No, that's exactly what he's dealing with. Paragraph 72.
2nd of June. Is this the letter?
Yeah, there's a typo. There's a typo, I think. Well, 2nd of June. The letter of response. Yes. This is what I'm taking you to at the moment. The letter of 2nd of June 2020.
Right. Where do I see the date?
It's on the
yes,
date of the letter.
yes.
It's at the page 4.
Yes. Right. So.
But we are talking about the same thing.
Right. So TSN Law's letter dated 2nd of June falls way short of evidencing that such invitations were made. Well, so it's not the letter that's falling way short of evidencing that such invitations were made. It's the letter which indicates that there is a shortage of evidence that the invitations were made.
So I'm sorry,
Well,
I don't
TSN Law represents Castle.
Yes.
Yes. So in this letter of response,
Yes.
what they're saying is, you've got the wrong end of the you've got the wrong end of the argument here, because we were in fact the agents of MSM rather than the other way around.
Mm-hmm.
But the judge says, I agree with Mr. Hart that TSN Law's letter falls way short of evidencing that such invitations were made.
Because my learned friend had taken the judge to that letter
So-
as evidence.
So
of specific
Mr.
intent.
McNeil had relied upon it.
Yes, Willie.
Right, okay. Rather than the letters, the welcome letters or anything else. It was this
He
letter.
also relied on the welcome letter.
Right.
That is true. But the principal thrust of his submissions at first instance were that this letter of response was
Now I
smoking
understand.
gun. And frankly, it was unsustainable for us to say that there weren't specific invitations because we had given the game away in our letter of response. I paraphrase, he was much more eloquent from that. But those were the thrust of submissions being made.
Right, all right. And on that basis, you say that whatever specific invitations were being made by Montague Smith, they weren't the specific invitations made on behalf, specifically of Castle, because Montague Smith represented or were looking for other providers. So they could have been making specific invitations in general, and then...
But they wouldn't have been on behalf of Castle because they weren't appointed to act on behalf of Castle. That's precisely my submission on ground 2. In the short time available to me, I should deal with ground 5.
Yeah.
And I can, I hope, be very quick on ground 5. And it's really as follows. And I sort of preface these arguments in my initial submissions on ground 4, which is that I say that Reliant Co doesn't change anything. One's looking for indissociable linkage. And so one then needs to look at the argument, not just in relation to the personal claims, but one needs to say in respect of Section 27 claim and the joint tortfeasor.
Can I ask you 2 questions? First of all, on the Section 27 claim, you accept there was an agreement. So why is there not jurisdiction as a result of the Section 27 claim?
Because it's not a contract for services. Again, it goes back to the question. Sorry.
Yes, sorry. So it doesn't. It's a separate point, is it? You say what? You accept that the Section 27 agreement. It's certainly a claim in relation to a contract. The Section 27 claim is a claim in relation to an agreement, and you accept an agreement exists. The agreement being the execution of the transfer of pensions. That's what we've established this afternoon. So, on that basis, subject to the specific invitation point, what is your the basis for rejecting jurisdiction on the Section 27 claim?
My lady, I don't accept that the agreement was an agreement, I think the relationship said to transfer the existing pension funds. I said
the agreement that you accepted exists.
The agreement was to execute the deed of adherence.
To exercise reasonable skill and care in the execution of the
deed of adherence.
Yes. So
that's not the regulated activity. That's not the regulated activity. To some extent, I go back to what Lord Justice Newey is grappling with in Adams and Options, which is that the relevant rights are trustee rights.
This is why I don't think, I have not understood your new, what seems to me, perhaps it was always subtly there, but this is an important point which is unexplored, which is we now have an agreement, we have a claim on an agreement, which is the Section 27 agreement, and you have a different basis for rejecting jurisdiction, as I understand it, and that basis, very slowly and simply, please, is?
That the relevant matters for the agreement to which the Section 27 claim would be in relation to, if there was an agreement, are pension fund trust rights, with Castle acting as trustee. The question of whether that holds Section 27 under the water, as my learned friend submitted, is, frankly, I submit a question for substantive.
I'm speaking entirely for myself, but I am simply lost by this section of your submissions. So I have to seek assistance somewhere.
Well, Mr. Hart, as I understand it, you're saying that the agreement that you do accept existed, which was to ensure the execution of the deed of adherence,
Yes.
is not regulated by Section 27.
Well, in fact, I take a step slightly before. Yes, but I take a step slightly before that. I'm focused on this being a jurisdictional area. I'm focused on what the pleading says.
Yes.
And what the pleading is taking issue with, the agreement that it's taking issue with, is not the administrative act
Section 27.
of executing a deed of adherence.
Right.
Right,
Okay.
Thank you. So the agreement that is the subject of the Section 27
We would have to go to the pleading out of Section 27.
Paragraphs 103 to 106. So the agreement that is being impugned is the transfer of the pension benefit. That is the agreement that I understand if you to accept that Castle agreed to effect.
I agree. I accept that Castle agreed to execute a deed of adherence.
Yeah.
Instead of the claimants doing it personally. I think that, I respectfully say that's different to the transfer of the accrued pension benefit.
Right. Second question. What if, contrary to your submissions, 1 or even 2 out of 3 claims are found to be within jurisdiction, and are your instructions that you would nevertheless, and we were to find the third outlier was not indissociably linked, are your instructions that you would want that litigated separately?
No, I get the same undertaking at first instance, which is we've no interest in splitting this across 2 jurisdictions.
So if one claim goes in, the other two or one, depending on our findings, go in as well.
We would submit to, my clients would submit to jurisdiction in respect of the other claims.
So why are we debating indissociably linked?
Because my learned friend has raised it, because you have to get, indissociably linked isn't just about, okay, there is an anchor claim and then there are remainder claims. It is finding any claim that is indissociably linked to a contractual service. And my submission is that there isn't a claim here that's indissociably linked.
I had misunderstood that. I thought the concept of indissociably linked was when you had different claims. One was, say, within, was a consumer contract. Then there were other contracts or other causes of action that were indissociably linked with the consumer contract claim. And that's the only issue that I understood indissociably linked to go. Now, if, in fact, if one goes in, your clients very sensibly say, well, if one goes in, I want it all done together. We don't, I think, need to worry about indissociably linked.
You certainly don't need to consider that aspect of indissociably linked. My understanding of indissociably linked, based on the CJU jurisprudence, is that it's a slightly different question, which is the question of what is a contract, that it is to be considered in a more expansive sense than merely taxonomic, so that you can have something that is not, as English law would recognise it, a contractual claim. Is nonetheless indissociably linked to a contract for, well, in fact, it applies both to Article 5.1 and Article 13. If I can explain it in these terms, in Calfellis, the CJEU adopted a hard and fast approach, that either you're in Article 5.1 or you're in Article 5.3. And as was clear in Gabriel, that could give rise to an issue of having claims heard in different places. And so they alighted on the autonomous definition of what relating to a contract means. They expanded that approach, what relating to a contract means. And so indissociably linked arises not only in respect to if claim 1 gets in, all the rest of the claims gets in. It also arises in the question of whether you have a claim that is not on its face a contractual claim. Is it nonetheless a claim that is indissociably linked with a contract? So in this particular set of circumstances, let us for the moment assume that the court is with me on ground 1 so far as the personal claims are concerned, and is with me so far as the joint tortfeasorship claims are concerned, but decides that Section 27 is indissociably linked to a contract for consumer services. That's where indissociably linked comes into play, because obviously a Section 27 is not a claim for breach of contract.
So it has got to arise from the contract.
Yes.
Yes.
Yes. Yes, my lady.
And what you're saying is that Mr. McNeill may have suggested, although I didn't take him to suggest this, but may have suggested that if we find that there was a Section 27 or there was a tort or well, just those two, then anything that was a contract, whether it was for services or not, gets dragged in.
No, for services. Services.
Yes.
Because we're in Article 30.
In
That's
your
the contract.
Right. So what I've just said to you is correct then?
Yes, that's right.
So I have not seen in any of the authorities indissociably linked coming up or being used in the context of determining whether something is a matter relating to a contract or sorry, a matter concerning a contract for the purpose of Article 13. Proceedings concerning a contract. I have not seen the phrase indissociably linked used in the context of determining whether or not proceedings concern a contract. And I may well be wrong, you're about to show me, but the test is not, are the proceedings indissociably linked with a contract?
I will endeavour to find.
Thank you. I'm sorry to put that up. I thought it was all indissociably linked was all with.
No, that's why it was important to listen to what Mr. Hart was saying about that.
My understanding is that that is what the CJEU is saying in Gabriel at paragraphs 47 to 49.
Thank you.
Right, let's go there now.
And that is the context.
131.
Sorry, I do apologize. It's page 131.
My fault. That's just saying they were undoubtedly linked contractually.
But it is the context, that is the context, that's the finding that the CJEU are making, which is the context in which paragraph 56 of Gabriel needs to be read, which is the first reference of indissociable arises. So
Yeah,
what the
sorry to
CJEU...
cut across you, look,
Yes.
whereas other actions that are linked so closely to that contract as to be indissociable, it's other actions being indissociable.
Yes, but the issue before the court in Gabriel is a claimant who can't bring a claim in contract, but is bringing a claim outside of contract, but which is indubitably or inextricably or indissociably linked with contract. So it's not a question of a claimant trying to bring two claims, one in contract and one outside of contract, at the same time in the same forum. That's just not the factual matrix.
But we're dealing with a claim in contract. Yeah. Well, we're dealing with, there is a claim in contract, but you say the question is nevertheless, are these proceedings concerning a contract for the purpose of Article 13?
Yes.
And you take us to 54 and 56 of Gabriel as well.
Yes.
You don't have to now, but I'm saying
But
that's
no,
probably
yes,
that's
my
what
point
you
is-
really
my
say.
point
It's for my benefit.
No, my point is merely that that passage, and I think my lady has this, that passage that I've just taken the court to, is the context in which to read what is said at 56.
Yes. Yeah, and 54.
And 54.
Yes. So we go 47, 48, 49, and then even if we don't want to read the paragraphs in between 54 and 56,
Yes.
and you say that brings it all together.
Yes. Now, in the time that I don't have available left, can I just address very quickly the joint tortfeasorship?
Yes.
And on that, I can be very brief, which is that I don't accept, if it is being submitted, that those claims are indissociably linked with contract for consumer services. And my basis for that submission is that what is alleged, and I have made this submission, so I'm repeating the submission, but what has been alleged against Gas is that it was aware, it was in a common design, it was aware of Montague Smith's negligence. And that, in my submission, is much closer to my lady's example of a trip and slip on the way to Montague Smith than, in fact, any of the other things that have been submitted. And that is just not anywhere near indissociably linked or inextricably linked with a contract for consumer services. It is a plain joint tortfeasorship. It is what it says. But my lady, to the point that you raised, if you're against me on any of the other claims, it's not going to particularly help me because we want this to be heard in the same jurisdiction.
But you're saying our focus should be on the contract for services.
Yes.
Right, okay.
Unless I can assist further, I rather over trespass my
Thank
time.
you for being patient with me, both you and you. Thank you.
Thank you very much, Mr. Hart. So, Mr. McNeil.
Well, I think I can get in quite easily under the 20-minute approach, hopefully. I've got only a few points in relation to my own friend's submissions. I'll take them in the order he took them. The ground floor point is I think important just in terms of understanding the instruments and that they are a continuation of the same underlying policy. My other friend did take you to the order in council, just in terms of what the judge must have regard to. And just worth just turning that up. And I think the judge himself accepted this sort of en passant, but if one goes to the order in council starts at page 11. It's page 13, Article 4. In determining any questions to the meaning or effect of the provision, any part of the provision made by Article 2 above, regard shall, so mandatory, shall be had to any relevant principles laid down by the European Court in connection with Title 2 of the 1968 Convention, and to any relevant decision of that court as to the meaning or effect of any provision of that title. And the judge himself accepted that, well, first of all, it's mandatory, you must look at these things. You could, of course, look at other things if they're helpful. And therefore, he was entitled to look at the two more recent cases, but in connection with he accepted was wider. So if the CJEU says, well, this is relevant to these instruments as they developed, and so, for example, as in Reliant Co, they refer to Gabriel, it's showing continuity, at least on the question of the multiplicity of actions point, the one-stop shop point. So we say that that's wide enough to get you to look at all 6 authorities anyway. My learned friend laid down the gauntlet on Petrichova, and I think just given a shortage of time, there's only really one point about Petrichova, but it's relevant to the point about joint tortfeasorship. If you're having doubts about what kinds of other claims might be in proceedings about a contract, and you're concerned that tort is not the kind of thing that's in that context, all you need to do in looking at Petrichova, I think it's at page 177, is again look at the type of claim being brought. So it starts at page 176, and it's a Czech claimant on this occasion. It's another, I'm afraid, internet platform trading for forex, foreign exchange, the things that people get involved in. Too much in my practice. And obviously losing money on a foreign exchange platform. But at H4 in the head note on page 177, as a result of a perceived loss of profit, Ms. Petrova brought an action before I won't try and pronounce the Czech version, but the regional court in Ostrava, Czech Republic, claiming unjust enrichment of FIBO. And the entire case then proceeds on the basis that that claim in relation to that contract in unjust enrichment was one that was properly brought within Article 13.3. If the three main elements of our law of obligations are contract, tort, and unjust enrichment, that seems a pretty broad approach. So once you have a contract with the platform provider, whether you articulate it in statutory measures like most of the cases we've looked at, or in unjust enrichment, as in the 5th case of Petrichova, or culpa in contrahendo in the 6th case, Reliant Co, they all are potentially indissociably linked with that contractual arrangement. And that's why the two most recent CJEU cases, I thought, below, put pay to much of Mr. Hart's arguments.
So do you agree with Mr. Hart that when one looks at a cause of action here, once you have a contract, the test is whether or not other causes of action are indissociably linked is the right test?
Yes, I think that I have to accept that. That's the phrase in Gabriel, which clearly is relevant guidance.
So I was confused or / wrong to say that I thought it was only a concept that deals with multiplicity of causes of action. What if there is a cause of action that is not breach of contract, but just a standalone pre-contractual obligation breach?
Well, my lady, if one looks back at the jurisprudence, not every jurisdictional court allows a multiplicity of causes of action. You can't, in some jurisdictions, bring a claim in contract and tort in the same claim form. We are quite, and some other member states are quite.
But in this case, in your case, and in the light of the pragmatic position being adopted, if you have a contract for services to which this matter relates,
yes,
then that would be an end of it, subject to meeting the other requirements.
But lady, I think that's right. But just to make the point good, I agree with that. To make the point good, if I'm good on ground one, and there is some contract for services, subject to what Miller and Friends says, I'm just not quite sure how far he's conceded on ground 5. But
well, what he's conceded is that if you can satisfy us that you do have the best of the argument concerning a contract for services, then he will say, well, I don't want to argue whether or not this is inevitably linked. I will go quietly. But what he was concerned about, that it appeared that you were saying that even if there wasn't a contract for services, if we were against you on that if we found that there had been malfeasance, then we could say, well, it doesn't matter that there was a contract for services, or that's how to interpret a contract for services. So that was why, in response to my Lady Justice Carr's point, well, why are you arguing this? Because you're conceding that one in the jurisdiction, all in the jurisdiction.
well,
That was the point that Mr. Hart was making.
if he has conceded that, it would obviously be ground 5 becomes moot. I accept that.
So on that basis,
But I'm not advancing a case.
You are certainly not submitting to us that any action regarding the claimants effectively must reflect that it was a contract for services. What you're saying is you can establish that per se. You don't need to go from the outside in, you go from the inside out, in other words.
Milady, if I get home on ground 1, having the better of the argument there, and he's making that concession on ground 5, I think
that's enough.
That's enough.
Yeah, so
Ground one and 2, as I said in my skeleton, they may be the 2 most important grounds.
Yeah.
In the case.
Right.
The judge bluntly held there is no contract here. I think that's what he held, as far as I could tell. And there was no specific invitation, but your ladyship has seen how he dealt with that pretty briskly, given the length of the judgment. That may shorten my remarks even more then. So Petroshova's point was it was an unjust enrichment claim, and that's all there is. On ground 1, very shortly, Lady Justice Nicola Davies made the really important point, and I think I mentioned this briefly, but as you go through the CJU cases, they stress the different sections of Title II, and that the basic rule of domicile is in the first section. The special jurisdiction rules are in Section 2, and the consumer contract rules are in Section 5 and 4. I'm grateful with it. But they are in separate sections, and it's my Lady Justice Carr's point. It is puzzling, my lady, that Gabriel 36 is very puzzling, and it is a piece of CJEU boilerplate that doesn't really seem to help anybody, I think. But if one goes back to Gabriel just briefly on 36, it is repeated. I mean, I just take it as being, well, there has to be a contract, and contract is an autonomous EU concept for jurisdiction purposes. So we don't look at offer acceptance, consideration, and intention to create legal relations. We take a more international view of what contract is. And if that's all the paragraph 36 is saying, I can live with that. I reject Mr. Hart's submission that the fact that there is some treatment of the different sections of Article 5 as being sort of silos is important in this case. I think the only relevance of Article 5 is the fact that the concept of contract is autonomous for European purposes, and therefore jurisprudence on what is a contract under Article 5 would be, in my submission, good jurisprudence on what is a contract under Article 13, and that is about as far as one could take.
But I think his point is actually, and it's consistent with his basic point on ground one, which is actually this is an Article 5.6 case.
Yes.
And because it's an Article 5.6 case, it can't be an Article 5.1 case. And if it's not an Article 5.1 case, it can't be an Article 13 case. What do you say to that?
But the short answer to that is, I mean, look at my claims. I mean, all three of them. But take the statutory claim first and foremost. Section 27. It's to reverse the agreement. I'm not seeking as settlor or beneficiary to enforce a trust. Quite the contrary. I'm saying that this trust should never have been established.
But this goes back to, I think, what is increasingly becoming the central point, which is what is the true scope of the services? Because if the true scope of the services was as you contend, which is to exercise reasonable skill and care in bringing about the transfer of the pension and then as scheme administrator,
Yes.
that would, as it were, cover, that scope would come within the scope of the agreement being impugned under Section 27 and elsewhere. Which is why Mr. Hart says, no, the services, the scope of the contract for services is limited, literally, to executing the deed on behalf of the individual member instead of the member personally. So I think,
Well,
thinking out loosely the way the arguments have developed, the scope of services is a very important point.
indeed, if one, maybe the place to go back to there, my lady, is just to their own letter of response. And the bit I took you to, which I think didn't feature in Mr. Hart's submissions, I took you to several hours ago, so it may not be fresh in your mind.
But it's important, the most important thing is that this is fair and accurate. Is my analysis fair and accurate on this? That scope of services may be,
Yes.
scope of the contract may be an important point.
Absolutely. And my lady, you have my particular claim, which quite carefully try and identify what agreement is being attacked under Section 27. It's an agreement to arrange and advise on a pension transfer in succinct form. But I did take you before, but I'll just take you again.
Was it really to advise on a pension transfer?
Well, as far as Montague Smythe is concerned, yes. So that's the regulated activity that gets you into Section 27, arranging or advising.
Yeah, it's just that you were referring to a contract.
Yes, and what I need for Section 27 is the investor, the intermediary, and the product provider, and for the intermediary to have engaged in regulated activities.
So that's the Section 25-26 point.
That's the 27 point, yeah.
The agreement that is the subject of the attack
Is the jurisdiction point.
Yes.
Is the pension transfer.
The pension transfer. So,
Bringing about the pension transfer.
Yes.
So,
And that agreement, sorry, it was my fault, Mr. McNeil, but that agreement, there's nothing you've taken us to that shows that Castle agreed to provide advice to the claimants.
No, I'm not alleging that.
No.
But I mean, there's the point about the clients, and we can develop this. But obviously, my clients are clients of Montague Smith as brokers, and there is no reason why they can't at the same time be clients of Castle as recipients of pension services. So that there's nothing in that point. Indeed, it goes to the joint venture point in some ways. That
Right. So
the brokers.
Take us to the letter.
The letter just describes what steps were taken.
Are we looking now at...
This is the letter response.
Yeah.
The lady here.
So this was the...
It's a supplementary bundle.
That's right. It's in
Starts at 40.
That's my lady's absolutely correct. Yes.
Yeah.
But it's a passage that I think didn't feature in Miller and Friends submissions, but I did refer to it in my submissions. It's pages 44 and 45.
Thank you.
And even the description and the facts in my submission as to what Castle accepts it did evidences that it and Montague Smythe were both involved in the pension transfer, and that involves services undertaken by Castle to effect the pension transfer. So it's so obviously the trustee again is established in 2009. By March, Mrs. Dooley has a transfer out request pack to take to her own seeding pension scheme. And then Castle received the self-advice letter which we allege was drafted by them from Mrs. Dooley. So before that, 26th of August, the claimant signed a declaration confirming her pension was to be transferred. Castle then receives a self-advice letter, and it's happy to act on a pension transfer without there being advice. And then on or about the 2nd of September 2014, the claimant completed and signed the Equus Retirement Annuities Trust Scheme application form, together with an authority letter authorising CTMS to approach her pensions provider, Macur, Police Pension Scheme. So I don't think we've actually seen that authority letter, but they do exist in the files. So they get the application form and authority for them as the pension provider to approach and deal with the existing pension provider in the UK. And the next one is the fees. We'll have to come back to that. But then the important bit, of course, as I try to illustrate, is on the 23rd of September 2014, Castle wrote to Macur, i.e. the seeding pension scheme in the UK, requesting the transfer of the claimant's pensions into the scheme and providing them with the necessary bank details, but the declaration made by CTMS as trustee of the scheme being the receiving scheme and enclosing a QROPS letter of acceptance from HMRC. Now, the point here is it accepts in its own letter of response that effecting a pension transfer involves it liaising with the outgoing pension provider and indeed satisfying the outgoing pension provider that it has the necessary HMRC authority to take pension transfers of UK-based pension assets. That goes beyond simply putting Mrs. Dooley on a deed of adherence and effecting it on her behalf so that she becomes a member of the trust deed. It is the whole process of satisfying the highly regulated pension provider over here that it is a sufficiently regulated and approved pension scheme in Gibraltar. I say without an authorised receiving scheme, these transfers can't take place. Can't transfer it to, it won't be transferred by any respectable pension provider in the UK to an unregulated person. So this is a professional financial service, holding themselves out as a professional, HMRC approved, to provide pension services in substitution for her existing pension services or pension benefits with the police pension scheme. And it goes beyond simply effecting one deed, admitting her to a trust. And that is my first two points of breach, which we can go to, allege, well, first of all, we shouldn't have been doing this with an unregulated intermediary. And secondly, just looking at the application form, Mrs. Dooley was clearly not a suitable person to be moving from a perfectly, well, one of the best pension schemes in the UK to a much riskier offshore venture.
Well, the heart of Mr. Hart's position on ground one is look at the duties and breaches pleaded in the particulars of claim. They are all tied to the trust deed and not to the contract. That is, what's the response?
The usual complaint I get is that my pleadings are tied to UK financial regulatory guidance. All of this is based on, there is one case of Mr. Justice Jacobs saying many of the things that we put down as regulatory duties here, but they're mainly based on the guidance of the Financial Conduct Authority and so on, which spell out what they see as the operational duties of pensions administrators. So that's the usual complaint I get. Not that I've taken it all from the trust deed. This is all based on a lot of literature, which I think is actually identified in it, in which the UK regulator says, what do we expect reputable pension operators and administrators to do?
So you said all these are based on the operational duties of
pension administrators and operators, lady.
Sorry?
Pension administrators or operators. So
So does that go to that phrase, scheme administrator, that I identified in the welcome letter on page 10?
Milady, yes.
Or
I mean,
not?
these are
Does.
in the UK. These are terms of art. The idea of typically they're called pension scheme administrators as opposed to trustees. The regulated activity in the UK is operating a pension scheme. So the word is operator for regulatory purposes. But these are
So these are the breaches, but Mr. Hart's point is you can't define a contract by breaches until you've defined the contract. So you say that you pleaded on the basis of your experience, which is obviously vast, of regulatory work, but you've still got to demonstrate that there was a contract between Castle and Miss Dooley et al.
indeed, but I say I have the best of the argument that this is a very routine contract for pension services. This is not a classic trust in which the trustees are acting voluntarily. These are remunerated trustees and scheme administrators who are undertaking a service, a professional financial service, which is a recognised activity across the pensions world. It's not surprising that they
Mr. Hart's
use.
saying that these are also the duties of a trustee.
Well,
And therefore, you've got to distinguish between those in order to make good your better argument.
well, Milady, yes. So, Mr. Hart has not at any point pointed to any point in my particulars of claim that are core duties of a trustee. Quite the contrary. All of our claims are about.
Sorry, I thought that's what he did say.
No, he
said if you
asserted
look
it,
at
but
the
I hasn't.
particulars of claim, this all derives from the trust.
Well, Milady, in my submission, he hasn't made good that point, and the bits of the trustee we've looked at do not provide much more concrete evidence of what Council was doing qua trustee under the trust deed. In the same way
you
that
have pleaded these duties, forgive me, as both breach of contract and breach of fiduciary duty. Your position is it is the client due diligence duty, and I'm looking at page 100, paragraph 112 of the particulars of claim, which is where Mr. Hart took us to the product due diligence, the valuation duty, the financial crime duty. Those are not exclusively duties that arise out of the trust deed. Is that your position?
No, indeed not. I mean, it's more akin. Put it this way, milady. In the 19th century, what our English judges did was spell out the standard incidents of sale of goods and those kinds of routine transactions. What is being done in the course of litigation and regulation is we're trying to spell out for firms like Macur and Friends what exactly it is they do, because their express terms don't tend to give us much evidence as to what the minimum decencies of what they should do are. And in fact,
you say these are administrator duties, operational duties, not just trustee duties.
They are almost entirely administration duties of a pension administrator, a pension scheme operator.
Okay. And it is in that context that the phrase scheme administrator is used.
Indeed. As the lady says, it's not just us who differentiate between administrator and trustee. The welcome letter does so.
It does it twice.
Indeed. So, without trying to give evidence from the thing, it seems surprising to me that there was this assertion that there is no recognised distinction between administrator of a pension scheme and trustee of a pension scheme, given that the documents emanating from Castle themselves seem to suggest they recognise that there are two hats they are wearing. And certainly, if I was claiming to enforce the trust, Saunders and Vautier give me the trust benefits or something like that, despite the tax consequences that would be involved. If I was seeking to enforce a trust, then a friend might be right, it's an Article 5-6 case, but this is a million miles away from a beneficiary or a settlor seeking to go and take remedial action about how the trust has been operated. The gist of our complaint is that this pension trust in Gibraltar should never have been established. That is the gist of our complaint, and that's clear on the face of the particular claim. Not to enforce the trust, but to reverse the trust. We want to go back. All of these claimants want to go back to the domestic UK providers, if they can. Some of them probably shut out, but that's the gist of this claim.
It's not that the trust itself was mismanaged, but that the trust should never have existed.
No, indeed. And that is the gist
You
of
just mentioned Article 5 and 13 in a nutshell. It's just on a short list of points I need your help on. How do you say we approach the waterfall analogy with Articles 5 and 13. You say that it's puzzling why the European courts say what they do, but we are bound to take what they say into account.
Yes.
So where do we land in the interrelationship between Article 5 and Article 13 on your case?
Yes, well, I think I tried to deal with it earlier in my response, but it is just this. All I take from paragraph 36 and
right, okay.
of Gabriel is the point that contract is an autonomous European concept, and that is what I take it to be getting at. If one takes up Gabriel just quickly on this point, in fact, your ladyship's concerns about mixing and matching Article 5 and 13 were shared by Advocate General Jacobs, who thought didn't make any sense either, but that in a couple of these cases, but it doesn't really take us much further forward. In Gabriel, sorry, just taking myself past it. Paragraph 36 is at 129. I think these are almost, as my other friend conceded, some of the boilerplate chunks the CJEU repeats. But in terms of practical guidance, I would emphasise paragraph 37 over the page, which actually makes more sense. It says, according to settled case law, the concepts used in Article 13 of the Brussels Convention must be interpreted independently by reference principally to the system and objectives of the Convention in order to ensure that it's fully effective. I mean, in terms of two bits of boilerplate, paragraph 37 seems to provide more guidance to this court as to how it should approach Articles 13 to 15 in its separate section. And I say what I'd say is that the most you can say about the Article 5, Article 13 relationship is that it's making the same point that contract must be an autonomous EU concept, both in Article 5.1 and in Article 13. And therefore one could look at the jurisprudence on both, if need be. There's a second point in relation to that, which I think was the cascade point. I think you asked my learned friend, do you then simply ask the question, is it a matter in relation to contract under Article 5.1? And then is it, asking the question, is it proceedings in relation to a contract under Article 13.1? And isn't the first step redundant, I think you asked my learned friend. My lady, for the reason I gave earlier, it's not quite the same question because, of course, if you're in Article 5.1 special jurisdiction, as I submitted right at the beginning of the day, it operates differently. So if you establish special jurisdiction over a matter in relation to a contract in a commercial case, the court simply has jurisdiction over matters in relation to the contract under Article 5.1. And that is why these are treated as being mutually exclusive. So if you can't satisfy Article 5.3, you can't bring tort, DLT claims under it. But the prefatory words of Article 13 do say proceedings in relation to a contract, and that does invite the court to ask a wider question. Is there a contract, and are these proceedings about a contract? Which is my one-stop shop point. So it is important to look at Article 13 as being a different question to the Article 5 question. Because one is then invited to look more widely about whether it's proceedings in relation to a contract. But my learned friend seemed to say, in relation to the fees paid, that he obviously points to the fact there is a written agreement that is signed by the clients with Montague Smythe to pay £2,000 or thereabouts. It is, of course, then sent to Castle and is then the basis on which Castle pays the money from the monies transferred from the UK pension scheme. There's a date discrepancy,
isn't there? October 2000.
Yes, well, I accept that. And in fact, we did realise, I have been through 60 odd of these 500-page plus files. And we accept that the fee schedule we've attached is not Mrs. Dooley's fee schedule. But there are other iterations of it. And I didn't think it was a major point, but there are the fee schedules all seem pretty similar over the period we're talking about, 2014
But
to
were they attached to
2016.
the terms and conditions to the application form?
Well, they do. As we plead, and Mr. Wilson gives evidence, every file has one of these.
That's not the answer to the question a lady asked.
So we say it was attached, yes. I mean,
Yes,
we say it's likely
that's
that,
it.
yeah.
No, so was it or was it likely to be?
We say we have the best of the argument that the fee schedule, or something like the fee schedule, was attached to.
So it would have been attached.
It would have been attached. I mean, that's just. It seems an uncontroversial point. We have about 50 of these at least, and we can produce them all if needed. But it's a small point. We accept the date isn't quite right for Mr. Dooley's. I suppose the intention would be, of course, is that the client signs the application form and retains some documents, including typically the fee schedule, but maybe they sent them back. So it's just a question of.
Well, we won't speculate.
I know exactly.
We better move on.
It's best to move on from that point. It's not a major one, but the key point really is the point that yes, it was an agreement that Montague Smythe could take the £2,000, but that was affected by the statement of account at supplemental bundle, page 11. So it's quite clear. It's an accounting exercise. Mrs. Dooley didn't write a cheque for £2,000. We see that £120,000 odd came in from Michelle.
So what's the point of that? Namely, that shows that.
Well, my friends seem to be saying that it wasn't his client paying the fees. But
Well, he's right in that. He was facilitating the fees. Castle was facilitating the fees, but it was Mrs. Dooley who was paying them.
I know, it's out of her pension, yes.
Yeah.
And
I'm looking at the time.
indeed. Oh, my lady, of course.
Mr. McNeil.
And I'm basically done, I think. But let me just double check. It is the point that this is part of the arrangements to the knowledge of the parties. I'm happy on ground two that any specific invitation has to be on behalf of the trader on the business. And in terms of joint venture, can I just quickly remind you, my learned friend didn't take you to paragraph 38 of the particulars of claim. It's not simply a knowledge-based joint venture. It's spelt out in paragraph 36 and in particular paragraph 38 on page 84.
He says joint venture isn't enough as a matter of law. What do you say?
Well, that's a matter for trial, my lady. Under English law, I mean, joint tortfeasors are acting pursuant to a common design. I mean, in this case, we allege to affect pension transfers, which is what
So you say that if it was a joint tortfeasorship, then Montague Smith would have been acting on behalf of Castle when promoting / inviting.
Well, lady, yes. And that's the joint venture is described in 38, and then there is the detailed knowledge that happens. I mean, I wanted to ask the rhetorical question when the friend was talking about it, where does Montague Smith get the application forms from that it provides to them? Now, the answer might have been, well, we have them on our website. I sometimes get that response, but...
Well, I think we're going off course.
Okay, my lady.
It's 20 to 5.
Indeed, my lady.
Mr. McNeil. The issue raised by Mr. Hart was that there is indication in the papers that the judge had reference to and specifically referred to in his judgment that, in fact, Castle were agents of Montague Smith rather than the other way round. And if that was right, then in that case, the specific invitation made by Montgomery Smith could not have been made on behalf of Castle.
My lady, that submission was not made below, and it doesn't appear in the judgment.
Well, he took us to paragraph 72, where the judge, in his judgment, said that he did not accept your submission, that part of the letter of response evidenced an agency. Far from it.
No, he says less than that, my lady, to be fair.
Well, he said, as to Mr. McNeil's alternate reliance upon Castle having made specific invitations to one or more claimants, I agree with Mr. Hart that TSN Law's letter dated 2nd of June 2020 falls way short of evidencing that such invitations were made and does not amount to plausible evidential basis for saying that they were.
Well, obviously the judge is plainly wrong about that, because it does. But there's no hint of principal or agency arguments my own friend tried to run on his feet today, which I don't think appears in his skeleton argument either. So it's suggested that what is being said, and I think it involves a misreading of his client's own letter, is that they are the agents of the intermediary in this case.
That's the point he made.
I know,
So
it's an interesting one.
If he says that the letter of TSN shows that, as he says, it can hardly be that Montgomery Smith were making specific invitations on Castle's behalf. Rather, they were making specific invitations on their own behalf, and they'd cast around and happened to come across Castle and said, well, you'll do.
Indeed. But this is a mischaracterization of a very straightforward business relationship. Montague Smythe, unregulated and dubious though they are a broker or intermediary. They put clients in touch with product providers.
They may do, but that doesn't mean they necessarily make specific invitations on the provider's behalf.
Well, to put it this way, it was my rhetorical question about where do the application forms come from. So obviously Montague Smythe is armed with a large number of application forms. They're also armed, if you go through the evidence of Mr. Wilson, it's worth going through the entire letter again because the judge seems to pay no attention to that important evidence. He describes in detail every single document that Castle required Montague Smith to get the claimants to sign up to. Most of them are basically disclaimers and exemptions of various sorts. But there's a whole suite of documents drafted by Castle, provided to these claimants by Montague Smith in the way that brokers and intermediaries behave.
Brokers are not usually agents for providers.
A lady made me the word. Yes, there's the old classic. Insurance brokers used to change sides in the old days as well, lady, didn't they? They could switch sides depending on what they wanted. But I'm using the word broker in a commercial sense here, really. They are sourcing, so that they need, as people trying to get people to make dodgy investments offshore, they need a product provider of a reputable pension. And in that situation, as I go back to my point, the claimants are clients both of Montague Smith, the intermediary, and clients of Castle. The two things are synonymous. We don't need to pin it down in terms of
You've still got
agency.
to pin down the specific invitation.
Well, I go back.
13.3.
I go back to at the very last point, the application form drafted by Castle, and provided to each of these claimants by Montague Smith.
And so when my Lady Justice Carr this morning asked you whether you say the application forms were the specific invitation, you were a bit reticent in saying yes, but you're now saying that's what it is.
As a final point, I think one looks at it holistically, I think ideally, but there's a final point in time in which you can say quite clearly this individual in a member state has been provided with an application form from the offshore provider and the consumer has completed it. So that
yes, is that what you're saying?
That's my case.
Specific invitation.
That's my case.
Right.
That's more than sufficient in my submission to have the better of the argument.
Right.
I'm conscious of the time. I apologise for counsel's time estimates notoriously.
They are notoriously bad, but we've all been there. So anything else, Mr. McNeill?
With the final point, I would recommend reading the evidence below in more detail because it seems to just pass the judge by. Mr. Wilson's evidence describes this process in quite a lot of detail. A lot of it's very similar to the particular claim, but it does describe the whole process in which these transfers occurred, which is not a simple case of signing up to one deed in Gibraltar. So I'd invite your ladyships to do that. I'm assuming that you're going to adjourn rather than
you can
deliver.
Assume very, very clearly that will be the case.
I remember Mrs. Dooley's case was the first of these to land on my desk, and it's a remarkably complicated situation that she has found herself in, I'm afraid. Yes.
Yes, it's a remarkably complicated and interesting case, so we will be reserving our judgments.
We're grateful for your help today.
Anything further, Mr. McNeil?
My lady, no.
Yes, thank you.
Anything you would know?
Thank you both.
Thank you. Thank you both very much indeed. In fact, thank all three of you very much indeed, because I've got no doubt that Mr. Steers played his part. We will reserve judgment. We will send out a draft of those judgments as soon as possible, but there's quite a lot to think about. As you know, you can correct our English, but not our reasoning. When you receive the draft, please can you, when making editing proposals, put those editing proposals into one document. It's to be hoped that the judgments are sufficiently clear in order for you to determine the nature of the order that we would make, and we would ask that you provide a draft. Any applications that arise as a result of the judgments, or indeed if there's any issue about terms of the order, please make submissions and or applications in writing at first instance.
My lady, yes.
Mr. Hart.
Yes, my lady, there's just one minor point. It's in relation to embargoes of draft judgments.
Yes.
I just want to check that the court are content with me to share the draft judgment with those instructing me.
In fact,
Gibraltar lawyers, not
yes.
officers of the court.
In
That's the reason
fact,
I
if
asked.
you look at the rules of court, it's very, very clear that the draft order may be shared with your instructing solicitor and the parties, but only under strict terms of confidence. The embargo was necessary because that confidence had been breached in relation to other cases. Yes, my Lady Justice Nicola Davies makes the point that the whole reason now for us sending out forms which have to be completed as to the names of the parties appearing and their representatives is for that very protective reason of making sure that if there is a breach of confidentiality, we know where to look.
I understand. I only raised it, as I say, because those instructing me are not officers of the court.
The requirement for that list came straight from the Counsel General of Wales case, and certainly my understanding of the edict that's gone out from the Master of the Rolls is it can only go to people on that list and no others.
Thank you. Thank you all very much.